Welcome back to Business Asset Protection. Mark Smith's my name. We're up to part 7, just of Section 40 of the Bankruptcy Act, and there is we're looking at acts of bankruptcy, and there is heaps and heaps of these acts of bankruptcy. And to be honest, we could go for a week and still probably not get through them all. So today we're just going to smash through the rest of them from Section 40 in brackets 1 in brackets HA all the way through to Section 40 in brackets 8, and there's a lot to get through. So strap in your seatbelt, and here we go. Well, here we are, Section 40 in brackets 1 of the Bankruptcy Act, and a debtor commits an act of bankruptcy in each of the following cases. Now, we've gone through A, B, C, D, E, double D, A, D, E, F, G, H, and we're now up to Section HA. If the debtor gives, and look, I'm sorry, this will take, we've got ages to go. We've all got to go all the way down to H, and I'm going to just skim through these. And I apologise, it is a skim. If you've got any questions at all, come to our website, bottom right-hand corner, dcpartners.solutions, and chat with us. And what does Section 2 mean? Part 2 of Section 40 of the Bankruptcy Act. What does Section Part 8 mean? So by all means, I understand it's a skim. We'll just go through these as quickly as we can, and we'll get through. And any questions, you'll come and talk to me offline. We're available anytime. Chat with us using the chat tools, or call us on 1300 327 123. Now, let's have a look at Section HA. If a debtor gives the official receiver, that's a mob called AFSA, afsa.gov.au, a debt agreement. So these are acts of bankruptcy, and once you commit them, you cannot go back from them. So very, very important that you know that it is an act of bankruptcy, and then you know that what the consequences might be. So a debt agreement. Now, we'll look at debt agreements later in our coverage of the Bankruptcy Act. We're only looking at what are acts of bankruptcy. So if you've got any questions about debt agreements or any of the other things that you come across coming through the rest of this particular video, message me offline. HB, if a debt agreement proposal is given by the debtor to the official receiver. So again, official receiver is afsa.gov. This is out. And it's accepted by your creditors. Well, that's an act of bankruptcy as well. So giving... and then if you breach that, HC, if you breach that, well, another act of bankruptcy. And so you can see that these can accumulate. So you might commit an act by giving the official receiver, HA, giving the official receiver a debt agreement proposal. But then if you breach it, there's another act of bankruptcy. And so you can see that all of these ongoing acts, a creditor, if you don't keep your end of the bargain, a creditor can use that against you in a creditor's petition. And we are going to have a look at creditors' petitions. That's why we need to wrap this up. If you, HC, if the debtor breaches a debt agreement, well, there you go. That is an act of bankruptcy. HD, if the debt agreement to which the debtor party was a party is terminated. So if you cease your obligations under that debt agreement, another act. If he or she signs an authority under Section 188, we'll look at Section 188 now at the bottom of this particular blog, or maybe it's right at the very top of dcpartners.solutions of the particular blog that you might be looking at on this video. You'll see a link to Section 188, so a tag, and so you can go and there's a tag for debt agreement, there's a tag for acts of bankruptcy. So if you want to go back and see all the different acts of bankruptcy, use those tags. Did we look at that? If he or she signs an authority under Section 188. So what does that mean? We'll go to the tag above and look at the Section 188 comments. Now, at the moment, there is no Section 188 comments, but they're coming. So this is a ongoing process. J, if a meeting of his or her creditors is called in pursuance of such an authority. Some of these things might make a bit more sense using the tags. K, if without sufficient cause, he or she fails to attend a meeting of his or her creditors in pursuance of such an authority. So you're getting the gist that once you're into this process of a formal process of insolvency, there are a number of potential acts of bankruptcy that can be used, and 99% of the acts of bankruptcy that are relied on in the courts is the failure under a bankruptcy notice. That's Section Part G. Okay, 99%. We'll just go back up to that. 99%, maybe 98% of the ones where someone does go bankrupt happen when you've issued a bankruptcy notice and a demand. Here, Ralph pays $106,551, and they fail. Okay, so 98% are of that kind. The other 2%, as I said, relate to some of these, I guess, more obscure methods of committing acts of bankruptcy, and they are nevertheless acts of bankruptcy which the courts can use to issue what's called a sequestration order. So that's a new concept, and there's a tag above, not on YouTube, but on our webpage. So go to our webpage, dcpartners.solutions, and this particular blog has a tag for what is sequestration. So there will be more and more of these posts and blogs and explanations about sequestration and other things. L. Where did we get to? Sorry, did we get to K? L. If having been required by a special resolution of a meeting of his or her creditors to execute a personal insolvency agreement, and then you fail. M. If a personal insolvency agreement executed by you is set aside by a court, or if it's terminated, or it means that once you're in, you can go to the next. There can be a further consequence. Okay, it's bankruptcy. Don't get me wrong; it can provide a lot of protection and a lot of I guess a protection is one way to look at it. A relief. It can offer relief to a debtor who accepts that they have unmanageable debts. If you only go part way in and you do one of these Part 10 agreements, again, up above, look at the Part 10 tag, and if you want to look at more content, if you go part way in, it can accelerate. You can go to, there can be further acts of bankruptcy, and that can have consequences. N, if a composition or scheme of arrangements, we can't possibly explain all of this one bit at a time, but if you've got a question, again, use the tags, call us 1300 327 123 or instant chat with us using the tool in the bottom corner. N, if a composition or scheme of arrangement executed under Division 6 of Part 4 is set aside. All these different concepts, again, these tags should help you. O, if the debtor becomes insolvent as a result of one or more transfers under the Family Law Act. So if you're, if you can't pay your debts because you've gone through a divorce, that can be an act of bankruptcy. You've got to be very, very, very careful. And it may not even be a divorce. You have one of these financial binding agreements. So these are prenups. These can get you into trouble as well. So an act of bankruptcy is you transfer out your assets to your spouse, your wife, your husband, your whatever, your companion. And these can have very serious consequences. So much so that you could find your entire estate. Your entire estate is subject to a sequestration order, possibly affecting your spouse. Like we can't look at all the powers right now, but the powers are immense. So let's go on to now onto Part 2. So this is Section 40 in brackets 2. A person commits an act of bankruptcy. Oh, no. Now, these are not where you commit them, but these explain a little bit further about the above acts. So in calculating, Part 2, in calculating for the purposes of Section 1D1, the period of which, that was where the sheriff turns up and attempts to sell your goods, your chattels, and maybe your property. These can be an act of bankruptcy. So if you find you're in one of these positions, either someone owes you money or you owe someone else any money, by all means, instant chat with us using the tool, or call us 1300 327 123. Section 3, or Part 3, for the purposes of Paragraph 1G. Now, that's the one where someone issues a bankruptcy notice and gives you 21 days now. It used to be 6 months during COVID. And, there are a lot of ways that you can get around this. All of these, we really can't go through, but there are ins and outs. That's what we will say. Ins and outs, and a lot of complexity. If you want us to explain it, by all means, give us a call, 1300 327 123. Section 40, Part 4. The act of bankruptcy in Paragraph 1J will be deemed to be committed. Now, I'll throw in a link to Paragraph 1J. We've gone through that, I think, today. I can't remember all of these. There are so many. So, look, I think in wrapping up, there is lots and lots and lots of complexity. And again, I think we're probably best to say, if you're in any position where the point is that there's lots of risks when you become insolvent or when you become under financial pressure, there are lots and lots of risks. And if you're exposed to one of those risks and you attend a meeting, you get a divorce, there are many, many risks. And so probably the best thing to do, if you think that you're facing trouble, give us a call, 1300 327 123, or use the chat tool, bottom right-hand corner, dcpartners.solutions. So we're actually going to move on next, probably here to bankruptcy notices, and we'll have a look at those. And if you've got any questions, by all means, chat with us, call us, 1300 327 123, or use the chat tools, bottom right-hand corner. Thank you very much.